All right, let's get started. Hello, everyone. I'm Ryan Johnson, and welcome to today's webinar, Digital, Mobile, and Virtual Medicine, Key Legal Challenges, which will be presented by me and my colleague, Catherine London. As I'm sure everyone on this webinar knows, digital health, including mHealth, telemedicine, remote monitoring, is transforming healthcare by providing consumers with greater control over their health and wellness and creating new platforms for reducing the cost and improving the quality of healthcare. Money continues to pour into the digital health space with an estimated $4.5 billion in venture capital invested in 2015 and an estimated 187 M&A digital health deals last year. Now, a key takeaway from this investment activity and M&A activity is that the market is really still focusing on the consumerization of healthcare with significant investments in consumer engagement and personal health care tools. Unfortunately, as is often the case, the existing state and federal legal and regulatory landscape, which is rapidly evolving, is not a perfect fit for the new world of digital medicine. Today, Catherine and I are going to focus on some of the key legal and regulatory issues of digital health, including virtual visits and mHealth. Now, given time limitations, today's presentation will very much be an overview of these legal and regulatory issues. Before we get started, a couple of housekeeping items. If you want to ask a question, you'll want to hover your mouse and select question. Q&A. We'll try to answer your questions at the end of the webinar, time permitting. If not, we'll follow up with you after this webinar finishes. Next month's webinar will be our always entertaining and informative colleague, David Glazer, who'll be talking about the new 60-day rule and repayment obligations generally. David will try to answer the questions: how does the new 60-day rule work? Do you have a legal duty to do internal audits now? What should you and what shouldn't you say in a refund letter? It should be a great webinar. All right, so today we're going to focus on virtual medicine, including telehealth and telemedicine, and it'll be what I'm focused on. And Catherine will be talking about mHealth, including a discussion of HIPAA and cybersecurity, one of the hottest issues in healthcare right now. All right, healthcare is experiencing a revolution, as you all know, driven largely by three forces: government regulation, including the Affordable Care Act, information technology, and consumerism. As consumers are being asked to assume more responsibility for their healthcare, in particular financial responsibility for the cost of their healthcare, the one-size-fits-all traditional approach to medicine is at risk of being overtaken by a highly personalized form of convenience care enabled by technology. And this technology includes mobile healthcare apps, remote monitoring, telemedicine, and virtual medicine. Now, within the past decade, we've seen the rise of retail clinics across the U.S. These clinics offer consumers a quick, convenient way of accessing healthcare in a way that causes minimal disruption in consumers' daily activities. Information technology provides greater connectivity, more mobility, more data, is opening the door to even greater consumer and patient convenience, allowing patients to get medical information at any time and from any location, be it at home in front of their computer or on the road, be it their iPhone or Droid. These technologies promise to reduce the costs, increase convenience and access of healthcare, and improve outcomes. Now, there are some key legal and regulatory issues that everyone entering the digital health space has to be aware of. And these cover most telemedicine arrangements, cover mHealth, which Catherine will be talking about later today. We'll be talking about licensure, scope of practice, prescriptive authority, reimbursement, the corporate practice of medicine, fraud and abuse, some FDA rules and regulations, the FTC, private security, and also, again, cybersecurity. So what is digital health? It's a broad definition that includes mobile health or mHealth, health information technology generally, wearable devices, telehealth and telemedicine, and personalized medicine. And again, just to note, there's a ton of investment activity in this space. Again, in 2015, digital health venture startups raised a record $4.5 billion, so up from $4.1 billion in 2014. So my focus today is really virtual medicine, not traditional physician-to-physician telemedicine, but more of a consumer consumer-facing service that allows patients, consumers to go online and receive a diagnosis, treatment, and prescription, again, all online. Examples include Virtuell, which is Health Partners' consumer-facing telemedicine platform, Zipnosis, a company that provides a virtual care platform for health systems and providers. Both of these companies were started in Minnesota, by the way, and Doctors on Demand. These models allow patients, again, to go online for convenient care, diagnosis, treatment, and prescriptions. This model, however, needs to be carefully structured to comply with many state and federal laws, with one of the most important being licensure. So the traditional rule is that practitioners must meet the licensing requirements in the state where the patient is located. This is one of the key issues in any telemedicine arrangement. Now, state laws regarding telemedicine vary in many ways. Some states have licensing laws that directly address telemedicine and explicitly define the practice of telemedicine. Some states indirectly address telemedicine by defining the practice of medicine to include diagnosing or recommending treatment through electronic means, and some states are silent. Now, some states require full licensure of practitioners providing telehealth services to patients in the state. Then they have an active or in-state practice requirement. Some states have special telemedicine licenses, including Minnesota and Montana. Some states have licensure exceptions for physician-to-physician consults or infrequent or occasional consultations, fewer than 10 consults per year. Now, one of the biggest barriers to multi-state telemedicine operations is our state-based medical licensing system. Now, fortunately, regulators are responding to this challenge, knowing how difficult it is for national telemedicine companies to operate and comply with all of the state licensure requirements. An interstate compact, it's a relatively new voluntary expedited pathway to licensure for qualified physicians who wish to practice in multiple states. It's been enacted in 12 states, including Minnesota, Idaho, Wyoming, Utah, Nevada, South Dakota, Montana, Iowa, Illinois, West Virginia, Alabama, and Wisconsin. The basic requirements for physicians under this compact require that the physician have a medical license in one of the compact member states, have a specialty certification, have no discipline on any state medical license and not be under investigation, and pass certain exams and completed a GME program. Now, eligible physicians in a participating state simply designate the state of their principal licensure and select the other member states in which they are seeking licensure. Now, the compact's not perfect. It does not provide one universal license for all participating states. It just makes it easier and faster to get a medical license in the member states. The compact also doesn't change any of the state's other medical practice act requirements. All right, another big issue in telemedicine arrangements is the scope of practice of the non-physician practitioners who are part of the arrangement. Scope of practice rules obviously vary on the type of provider or practitioner who's doing the consultation. In many models, it's simply too cost prohibitive to have the physician be the primary consulting practitioner online. Instead, the physician takes more of an oversight or supervisory role in many arrangements. And a nurse practitioner, registered nurse, or other licensed professional is the one actually directly interacting with the patient online. If a nurse or nurse practitioner will be doing the consulting, you'll first need to determine whether there's any physician supervision component or requirement. And again, physician supervision rules vary by state, and they're not a perfect fit for the way in which medicine is practiced today. So there are different levels of supervision. These come out of the Medicare rules. General supervision requires that a procedure be furnished under a physician's direction and control, but a physician's presence is not required. Direct supervision for certain types of tests and procedures requires that the physician be present in the office suite and immediately available. Another level of supervision is personal supervision, requiring the physician be in attendance in the room during the procedure. Now, again, given how powerful today's communication technologies are, some of these supervision requirements don't make a lot of sense, especially in the telemedicine or virtual health context, and how they would be applied by, say, medical boards is not crystal clear. Direct supervision or on-site requirements can significantly impact telemedicine arrangements. So it's important for any telemedicine provider to understand the applicable supervision requirements to make sure that, of course, the provider does not get into the regulatory soup. Question is remote supervision acceptable? Telemedicine technologies obviously allow for very meaningful supervision. But again, the way the supervision rules have been developed over time, they're not a perfect fit for the way telemedicine is practiced today. One of the key aspects of many virtual health arrangements is the ability of patients to go online and get a prescription when necessary. So it's important to make sure that the licensed professionals who are providing the virtual care actually have prescriptive authority. In determining that, it's important to look at state pharmacy statutes and regulations, licensing board policies, Medicaid reimbursement policy if you're interested in Medicaid reimbursement. And again, many of these rules are very state specific, and what's required very much is different in many states. For example, many states require that that there be a face-to-face encounter to establish a patient relationship before a prescription is made online. Many payers and providers are pushing hard to clarify the requirements and change the law to accommodate online consultations. This face-to-face requirement, again, doesn't make a lot of sense given the way telemedicine is can be practiced today. A question, if a physical exam is required before a prescription can be written, can that exam be performed electronically? Often the exam is required under state law to be required to be performed in person. If it's not required to be performed in person, does it have to be in real time? Can it be an adaptive questionnaire? How can you perform that initial examination before issuing a prescription? Again, questions, who can prescribe? What substances can be prescribed? Are there any telehealth exceptions? All right. Not in the slides before we get to reimbursement is the issue of credentialing and privileging. These have been big issues that have caused substantial heartburn for telehealth providers over time. Credentialing and privileging are related concepts and processes for evaluating the competency of healthcare practitioners. Credentialing is a process by which hospitals and other healthcare entities verify certain information about a practitioner, including education, training, and experience. Privileging is a process by which practitioners' competency provide services in a specific area or specialty is evaluated. Now, these have been big issues for telehealth providers historically because multiple facilities are often involved. And if a practitioner is located at one site, provide services to a patient located at a different site where the practitioner has not been credentialed or privileged, that can create issues. In May of 2011, many of these issues were resolved with the publication of the final rule providing that hospitals and other entities receiving telemedicine services may rely on the credentialing and privileging decision of the hospital providing the services, otherwise known as the distant site, thereby eliminating the requirement for separate credentialing and privileging by the receiving hospital. Now, reimbursement, this is obviously a key component of any business. And Catherine will touch upon this for mHealth and mobile apps. But in the telemedicine context, employers and individuals and many payers really are embracing the telemedicine model. It's convenient. It's often less costly, according to many studies, than a traditional visit to a physician practice or an emergency room. The government is playing catch up. What you'll see in your materials in the PowerPoint are some of the Medicare reimbursement requirements. The takeaway for now is that there's limited reimbursement under Medicare for Part B services furnished by a physician delivered via telemedicine to an eligible beneficiary. But certain requirements have to be met. There are geographic locations. Only certain services are covered. Only certain types of institutions can deliver the services, and the service had to be delivered by specific types of providers. And all those requirements are in your materials. I'm going to jump ahead, giving time limitations to a section on the corporate practice of medicine. So bear with me as I skip several slides here. All right. So as you know, many for-profit business entities are entering the healthcare space, often focusing on apps and digital health. They're sometimes partnering with existing physician practices or hospitals. And in these arrangements, it's important to make sure that they're structured to not violate state corporate practice of medicine prohibitions. The majority of states prohibit the corporate practice of medicine. I think it's roughly 35. Now, the corporate practice prohibition prohibits business corporations from employing medical professionals, owning medical practices, or controlling the clinical aspects of the medical practice. The prohibition seeks to prevent lay control over medical judgment, the idea being that profit-seeking incentives might lead to overutilization or poor quality or inappropriate healthcare. Now, it's important to note that the corporate practice prohibition, when it exists in a state, doesn't cover all licensed healthcare professionals. It might not cover nurse practitioners, it might not cover chiropractors, or it may. But it's important to understand whether it applies to your arrangement, the state you're in, and which professionals are covered. If an arrangement is structured in a way that violates a state corporate practice prohibition, there are a number of bad things that could happen. A payer might refuse to pay claims. There might be an injunction against the continued operation of the medical business. There could be criminal prosecution for engaging in the unauthorized practice of medicine, and other bad things could happen, actions against the license of the licensed healthcare professionals, the loss of the license, et cetera. So make sure you structure these the right way. If there is a state corporate practice prohibition, there are ways to structure businesses to comply with state law. One of the most common is the management company structure, in which a management company is created that typically owns all of the non-clinical assets. And that company will enter into a management service agreement with a professional corporation owned by the appropriate licensed healthcare professional, a physician, a nurse practitioner, a physician assistant. That PC provides all the medical or healthcare services that are covered by the corporate practice prohibition or subject to it. The management company, again, provides all the non-clinical services, often has the name, has the intellectual property, provides billing support, it helps with marketing, often helps find space. All the non-clinical activity takes place in the management company. The professional corporation provides professional services. This is a well-known model that is often used to set up businesses to avoid running afoul of state corporate practice prohibitions. But again, this is a very state-specific prohibition, and how much control a management company can have, what provisions can be in the administrative services agreement with a professional corporation. Again, it's all very state-specific. So if you set up one that works in Minnesota, you want to make sure it works in California if you're going to California, New York. Some states are much tougher on this, California, New Jersey, New York, than others. So if you do have a corporate practice issue and you set up a management company structure, again, make sure that you understand the corporate practice requirements in every state you're going into. Skipping ahead. Of course, there's a risk with this structure. The owners of the professional corporation may seek to void the entire agreement. If you look at the case law that's out there or Attorney General opinions, oftentimes those who are seeking to challenge the arrangement are often the owners. Those the management company brings in as partners in the arrangement are often the ones who seek to have the whole thing voided, either to escape an obligation or to try to increase the share of the revenue or profits that they bring in. Also, they're not structured the right way. The management company arrangement could be viewed as a sham, and then you have a corporate practice violation problem, again, with all the bad things from a prior slide. A related concept is fee splitting. Most states prohibit the splitting of fees between professionals and non-professionals. The policy concerns there might be a temptation for a physician or other licensed healthcare professional and a non-professional to maximize profit through medically unnecessary services, or a temptation for the physician or other licensed healthcare professional to limit medically necessary services in order to maximize income. When setting up a telemedicine arrangement, you're working with another company that's licensing the technology. You want to make sure you structure any kind of management agreement, software license agreement, marketing agreement, professional service agreement in a way that doesn't create fee-splitting issues. A related concept. This wouldn't be a healthcare webinar. We didn't at least spend a few minutes on the federal anti-kickback statute and Stark law. The federal anti-kickback statute, as most of you listening know, prohibits the offering, paying, soliciting, or receiving any remuneration in return for business for which payment may be made under a federal health care program, Medicare, Medicaid, or TRICARE, or inducing purchases, leases, orders, or arranging for any good or service or item paid for by a federal health care program. Remuneration is defined broadly to include kickbacks, bribes, and rebates. It can be in cash or in kind. It can be direct or indirect. Running afoul of the anti-kickback statute can create big problems, including criminal and civil penalties, substantial monetary fines, imprisonment. There's False Claims Act exposure. Again, it's important to make sure you structure arrangements with telemedicine providers, management companies, licensors, to comply with the federal anti-kickback statute if federal health care program money is going to be coming into the arrangement. Some relationships to look at: relationships with supervising or collaborating physicians, relationships with the management company, again, licensor of technology, there's software involved. Again, to make sure that it's not structured in a way that someone might believe that there's remuneration being offered or paid to incentivize referral or ordering activity. Some other takeaways: there's no issue if federal healthcare programs are not involved at all. Many kind of startup companies or more entrepreneurial companies coming into the market often avoid federal healthcare reimbursement at the beginning, at least, to avoid some of the regulatory hassles and potential big problems if they take Medicare or Medicaid money. But remember, even if you exclude federal healthcare programs from the arrangement, many states have their own version of the anti-kickback prohibition. For example, in Minnesota, we have 62J23, which says we're going to basically incorporate the federal anti-kickback statute as a matter of state law, but we don't care who pays the bill. So it applies to commercial payers as well. Some of the regulatory hassle associated with federal healthcare programs can often be a reason to go cash only. Again, lower risk, but there's a loss of an income opportunity, Medicare, Medicaid money. If you are going to accept federal healthcare program patients, again, make sure you structure your arrangement the right way. If you can, and you often can't, try to stay within a safe harbor or as close there to as you can get. There's guidance and advisory things we often look at, including some specifically applicable to telemedicine arrangements. All right, the Stark Law very briefly. The Stark Law prohibits a physician from making a referral for certain designated health services to an entity with which the physician or immediate family member has a financial relationship, unless one of Stark's many exceptions applies. Stark also prohibits the entities that receive the referral for submitting those claims to DHS. Only certain specific Medicare services are covered by Stark. If your telemedicine arrangement does not include them, or your mHealth, your app, you're probably in a pretty safe place. If you are going to be involving Stark DHS anyway, make sure that you structure the arrangement in a way that complies with the Stark Law. All right, briefly, online visits, malpractice risks. It's very much an evolving standard of care for what's appropriate in the telemedicine or virtual health context. Many national associations are working on clarifying the standards of care. There's not a lot of case law. There's still a small percentage of care delivered online. Settlements are often not reported, and many settlements often include confidentiality provisions, etc. There is one criminal case that I point out here. It's really more of a jurisdictional case. This is Hegseth versus the Superior Court of San Mateo County. In that case, a Colorado doctor participated in online pharmacy. The doctor issued an online prescription to a patient in California and was then charged criminally with practicing medicine without a license in California. Hegseth claimed that he couldn't be charged with a California crime because he was beyond California's jurisdiction. The court disagreed, finding that under traditional principles of extraterritorial application of criminal law, the state of California could reach the doctor. Some best practice kind of takeaways. Online visits risk management. Peer review is often helpful. You'll have robust physician supervision of licensed healthcare professionals who are part of the arrangement. Chart reviews. Monitor developments in continually evolving clinical practice guidelines. Use evidence-based treatment guidelines. Check with your insurance carrier to make sure you have insurance for the visits. Obviously, limit the scope of practices and services to what's appropriate for an online encounter. And think about and address continuity of care issues to make sure that the patients you see online can be referred to the appropriate facility provider in a way that addresses continuity of care issues. And with that, I'll turn over to Catherine for mHealth.
Thanks so much, Ryan. So I'm going to switch gears only slightly to talk about the regulation of mHealth, as well as privacy and security issues in the digital health space. And as Ryan mentioned, I'm going to end with a discussion about some general cybersecurity issues. So first, what is mHealth? mHealth refers to the use of mobile devices and generally wireless technology in medical care. And most commonly, this term is used to refer to mobile medical apps. So there are an estimated 500 million smartphone users who access or use mobile health apps in 2015, and this number is continuing to grow. The regulatory landscape is evolving, and that's what we hope to focus on today in our discussion. This slide just shows generally the types of mobile medical apps that are available on the market through either the Apple App Store or Google Play, and you can see they relate to a wide variety of healthcare conditions, and this is as of April 2015, but again, this number is continuing to increase as more funding is flowing into the mHealth space. I'm going to talk first about regulation of mHealth and mobile medical apps by the FDA. As general background, FDA regulates medical devices, as that term is defined by the Food, Drug, and Cosmetic Act. And I've included on this slide the definition, but generally, device is broadly defined to include essentially anything that can affect a disease state or structure or function of the body. FDA issued guidance, long-awaited guidance, in September of 2013 on mobile medical apps and how it intends to regulate mobile medical apps as medical devices. And in this guidance, FDA explained its focus on apps that will present a risk to patients if they don't work as intended, as well as the apps that present a risk to patients if they don't work as intended, as well as apps that cause smartphones or other mobile platforms to impact the functionality or performance of traditional medical devices. And more recently, FDA guidance was updated in 2015, and again, this is just non-binding guidance from FDA, but the more recent guidance further clarifies FDA's position and identifies the three categories of mobile medical apps, which include apps FDA will not consider to be medical devices, even if they relate to health, apps FDA will regulate, and then apps for which FDA intends to exercise discretion and will not regulate at this time. So I'm going to talk about each of these categories, and specifically FDA's focus on the subset of apps that meet the definition of a device and that are intended to be used as an accessory to a regulated device or transform a mobile platform into a regulated medical device. And the recent guidance confirms FDA's focus is on functionality and not platform. So as usual, intended use is key here. If the app is intended to be used for diagnosis, treatment, or prevention of disease, or to affect the structure function of the body, FDA will consider this to be a device and subject to its regulatory review. The first category I want to talk about is mobile apps that connect to a device for purposes of either controlling the device or for use in active patient monitoring or analyzing device data. And FDA considers these types of apps to be an accessory to the device that extend its intended use, and therefore FDA believes that the app must comply with regulatory controls that are applicable to the device itself. So one example is an app that controls delivery of an insulin on an insulin pump. And I should mention that FDA considers this type of app to be high risk in terms of the potential for patient harm, particularly if there's a breach or data vulnerability, which I'm going to discuss a little bit more later, but this has been the focus of some recent hacking issues. The next category are apps that transform a smartphone or a mobile platform into a regulated device by using attachments or other types of display screens or sensors that are similar to those of a regulated device. So for example, an attachment of a blood glucose strip reader to your mobile phone that allows the phone to function as a glucose meter would be one example of an app that falls within this category. And the last category of regulated apps are those that become a regulated medical device because they perform patient-specific analysis or provide patient-specific diagnosis or treatment recommendations. For instance, apps that use patient-specific parameters to calculate dosage for radiation therapy. Now, there are certain apps that can walk a fine line between falling within this category or the category of unregulated general reference apps. And the key here is as soon as the patient-specific data and treatment recommendations are involved, FDA is going to become interested in that particular app. And this is similar to past practice where, for instance, a bathroom scale would not be considered a regulated device, but as soon as the scale is designed and intended for medical use or in the process of diagnosis, FDA will consider this to be a regulated medical device. Moving on to some examples of apps that FDA has decided not to regulate as medical devices. These include general apps that provide access to medical reference materials, apps that are intended to be used as educational tools for patients or providers, as well as apps that automate general office operations in a healthcare setting, for instance, billing programs. And the last category is the apps for which FDA has decided it's going to exercise its enforcement discretion at this time. And these are mobile apps that technically meet the definition of a device, and FDA has authority to treat these as devices, but has decided to exercise discretion in part because of their low risk and also because of the enormous task of having to take on this flood of apps, which we know FDA is already kind of struggling to keep up, and this would be a huge, huge regulatory burden if they decided to regulate these apps. As a few examples, these could include apps that help patients self-manage their disease without providing any specific treatment suggestions, so medication reminder apps. They're tools to track healthcare information or allow patients to communicate with healthcare providers. And then finally, also includes apps that enable patients and providers to interact with EHR systems. The last thing I'm going to mention on this topic is that the FDA guidance also clarifies that the mobile medical app policy does not apply to any entities that solely distribute medical apps, such as the iTunes Store, and also will not apply to licensed practitioners who create mobile apps solely for use in their professional practice, so long as the apps are not available to others as a general matter. But as soon as the professional wants to make those apps available more generally for use by the public or by other professionals outside of their practice, it can easily move into a regulated category of devices. I want to touch briefly next on the FTC, which has also taken an interest in mobile medical apps in recent years. And as general background, FTC regulates consumer protection issues, and FTC laws prohibit unfair and deceptive trade practices. These laws apply to all mobile apps just like they would apply to any other consumer product. And in general, any disclosures need to be clear and conspicuous. Endorsements are all subject to truth in advertising requirements. And then importantly, any advertising claims must have a reasonable basis. So in the healthcare space, this means Any health and safety claims need to be supported by competent and reliable scientific evidence. There have actually been some settlements in recent years, FTC settlements involving mobile medical apps. One involved Ultimize, and they had a vision app that the FTC claimed the company did not have scientific evidence to support its claims that the app could improve users' vision. And there were also some settlements recently involving melanoma detection apps that allowed users to actually photograph their moles with their smartphone and then input other information into the app about the mole. And then the app would calculate the user's melanoma risk. FTC alleged that these companies had deceptively claimed the apps accurately analyzed melanoma risk and could assess risk even in early stages, but FTC claimed that marketers lacked adequate evidence to support these claims and prohibited the companies from making any further claims unless they were supported by scientific evidence in the form of human clinical testing. FTC, in light of the proliferation of mobile medical apps, has released some best practices for mobile app developers, and most of these are related to privacy and security issues, which I'm going to touch more on in a minute. But basically, app developers should do their best to minimize the amount of data collected and retained, and de-identify data if possible. Should also limit access to information and use permissions, keep authentication in mind, implement strong password protections, and make sure to think about and incorporate data security at every stage of the app's life cycle. FTC also recommends performing appropriate due diligence and security testing to make sure that any third-party service providers or mobile platforms that are being used will adequately protect user data. Finally, just a couple last comments on this topic that FTC recommends are to communicate with users regarding security options and privacy features and take advantage of any other easy tools on the market that help safeguard consumers' personal information. I wanted to at least include on one slide that FTC did release a new tool very recently that is intended for app developers to help them understand what federal laws might apply to their apps. So it just kind of walks you through a number of questions that identify whether the apps might be subject to regulation by FDA, FTC, FCC, or what type of HIPAA requirements might apply. Moving on to privacy and security, which is obviously a huge issue. And I'm going to try and dive into the extent we have time, but should note that HIPAA is not going to be the focus of today's discussion. We have a number of other webinars on HIPAA if you want a deeper dive on this issue, but we are going to focus more on its applicability to digital health and mHealth, and then focus on cybersecurity issues in this space. So please check out our other webinars on this issue. But as general background, most of you know that HIPAA is applicable to covered entities and business associates and applies with regard to protected health information, which is individually identifiable information created or received by a healthcare provider that relates to an individual's health, the provision of health care to the individual, or payment for health care, and that identifies or provides a reasonable basis to identify the individual. The HIPAA privacy rule generally prohibits use or disclosure of PHI in a manner that is not permitted by the privacy rule. And again, we're going to kind of focus on issues that are of particular applicability and interest in the digital health space. And one is marketing, which is prohibited without a patient's authorization. And this is an issue of interest at any time clients, we work with clients who want to text or email patients. We usually have to have a discussion about what type of message is going to be sent in those texts and whether could trigger the HIPAA marketing requirements. And under HIPAA, marketing is defined as a communication about a product or service that encourages recipients of the communication to purchase or use the product or service. And there are a few exceptions to this marketing definition, and they include communications for treatment of an individual by a healthcare provider or to direct or recommend alternative treatments, therapies, providers, or settings to that individual. And note that this exception only applies to the extent the covered entity does not receive any financial remuneration in exchange for making the communication. Another exception is related to communications that describe a health-related product or service that is provided by or included in a plan of benefits of the covered entity. And again, these exceptions apply only to the extent there's no financial remuneration received in exchange for making the communication. And then finally, there is also an exception that applies to refill reminders for currently prescribed drug or biologic. But one important thing to keep in mind is even if you are certain that you're complying with HIPAA, there are a number of other federal and state laws which could potentially impact the use of mHealth or even wireless medical devices by consumers and healthcare professionals. And one such law is the Telephone Consumer Protection Act. And this law is enforced by the FCC. As kind of general overview, FCC regulates interstate communications involving radio, television, wire, satellite, and cable. And so it's taken interest recently in medical devices and mobile health technologies, given that there are so many devices that increasingly rely on wireless communications. So FCC is another regulatory agency that should be on your radar if you are working in this space. But as background, the TCPA requires prior express consent from consumers before placing any automated calls or text messages to a consumer's wireless phone. Under the TCPA, the consent requirements differ based on whether a call or text contains a commercial or a non-commercial message. And a commercial message is one that contains an advertisement or a message for the purpose of encouraging the purchase of property, goods, or services. If the call or text has a non-commercial message, so this could be an appointment reminder, this would require consent, which could be provided in writing, electronically, or verbally. By contrast, if a call does contain any commercial message, then the consumer's express written consent is actually required. We worked with clients for a number of years on TCPA issues, and then very recently, in this past July, the FCC issued a declaratory ruling in which it clarified the application of the TCPA to healthcare providers and confirmed that providing a phone number to a provider does constitute prior express consent for any healthcare calls that are subject to HIPAA by covered entities and business associates. And this exemption, according to the FCC, applies only to calls or texts that are within the scope of the consent provided and only for healthcare-related messages by a provider. So, for instance, any messages related to insurance coverage, according to the FCC, would not necessarily fall within this exemption. The ruling also clarified a limited exemption for certain healthcare-related calls and texts for which there is exigency and which are made for healthcare treatment purpose. And I've included on this slide the types of messages that FCC included in this ruling would fall within this exemption. But note that there are several conditions that apply or that must be met in order for this exemption to apply. So if you are considering texting patients or sending any automated kind of messages to patients, you should be well aware of this new ruling and make sure that the TCPA, in addition to HIPAA, is on your radar. I'm going to move into the HIPAA security rule and security generally. As background, the HIPAA security rule, as most of you know, requires implementation of certain administrative, physical, and technical safeguards to protect electronic PHI. Covered entities and business associates are required to ensure the confidentiality, integrity, and availability of ePHI, protect against reasonably anticipated threats and hazards to ePHI, as well as anticipated impermissible uses and disclosures of electronic PHI, and to also ensure compliance by all workforce members. In deciding on what security measures to use, covered entities and business associates are required to consider issues that include the organization size, complexity and capabilities, technical infrastructure, hardware and software and security capabilities, the costs of implementing various security measures, and the probability and criticality of potential risks to EPHI. That's just a very, very broad overview of the security rule, and I am going to kind of use that as the general background to discuss cybersecurity, which is an issue that has been attracting more and more attention in recent years. And cybersecurity risks in the healthcare industry are constantly evolving. Healthcare sector is one of the most vulnerable sectors, and healthcare information is some of the most valuable information to hackers. So the main issue here is that cybersecurity is very complex, and it involves mobile devices, networked medical devices, EHRs, interoperable health IT systems, and attacks are getting even more and more sophisticated. So for instance, a ransomware attack on MedStar Health that just this past year required the healthcare provider to take its EHR system offline for several days, and this was its entire EHR system. So it's getting very difficult to kind of keep up with all of the risks in this area, given that the risks are constantly evolving. There's a growing emphasis on medical device cybersecurity in recent years, given the proliferation of devices that connect to the internet and also connect directly to provider networks. And in devices such as pumps, heart pumps, and pacemakers can be hacked, and these types of hacks can not only result in data breaches, but also can significantly affect patient safety. So for instance, in August of this past year, FDA issued 2 warnings about certain vulnerabilities of a medication infusion pump that FDA considered to be particularly vulnerable to hacking, which could allow unauthorized users to access and remotely control the device. And this was actually the first time that FDA issued a warning to providers, directing them to actually stop using a product due to cybersecurity risk. And for that reason, FDA has started to take a closer look at cybersecurity issues. And in October 2014, FDA published guidance that was aimed at assisting companies with pre-market submissions to ensure that the submissions adequately address cybersecurity issues. And then very recently, in January of this year, FDA issued draft guidance, so just in draft form at this point, that addresses its expectations with regard to post-market cybersecurity. The post-market guidance recommends generally that manufacturers of medical devices monitor, identify, and respond to cybersecurity vulnerabilities as part of routine post-market surveillance. And the guidance emphasizes the importance of participation in an information sharing analysis organization, which is a group that has members in the public and private sector that are required to share cybersecurity information among the members. And it's interesting to note that this guidance comes shortly after the 2016 OIG work plan, which indicated that OIG intends to examine whether FDA's oversight of hospitals' networked medical devices is sufficient to protect electronic PHI. And OIG indicated that it would be focusing on dialysis machines, radiology systems, medication dispensing systems, and other devices that are integrated with electronic health records or just a provider's larger health network. Without going into too much detail on the content in the draft guidance, the post-market guidance recommends generally that manufacturers implement a comprehensive cybersecurity risk management program as part of compliance with the QSR, and also respond in a timely fashion to identified vulnerabilities. And the guidance sets forth a number of components that these programs should include, and those include monitoring cybersecurity information sources to identify and detect vulnerabilities and risks, understanding, assessing, and detecting the presence and impact of a vulnerability, having processes in place for vulnerability intake and handling, having a coordinated disclosure policy in practice, deploying mitigations that address risk early, defining essential clinical performance to protect, respond, and recover from cybersecurity risk, and also applying the 2014 NIST framework for improving critical infrastructure cybersecurity. So what are the takeaways at this point? I think some key takeaways on the cybersecurity front are that the cyber threat landscape is constantly evolving, and the healthcare sector is potentially the largest sector at risk. And the continued expansion of digital health creates new vulnerabilities that need to be managed across the healthcare industry. So risk assessments are as important as ever. You should know where your data is, who has access to the data, what vendors are potentially using data, and how are the vendors using data. You know, addressing these issues in contracts is going to become more and more important in the coming years. Providers, manufacturers, and mobile app developers need to know the vulnerabilities and, most importantly, need to be prepared for a breach because they will happen. Incident response plans are very important. Have a good understanding of how your organization could respond to a breach if it does occur, or more likely when it does occur. Cyber liability insurance is another consideration, and it's an issue that's becoming more and more popular. There was a recent case in which I believe it was a Fourth Circuit case that involved traveler's insurance, and the case was one that involved a general liability policy and cyber threats that resulted in disclosure of patient data and a significant breach. And in that case, the court decided that the general liability policy would apply to this particular risk. And this case received a lot of attention because I think people were using it to promote the idea that, oh, your general liability policy can apply to these types of risks, but it's important to remember that more often now many of those policies will have specific cyber liability exclusions, and I think you'll see that more and more in the upcoming years. So it's certainly something that you should consider if you have not considered already. And then final word of caution is be careful with legacy devices. These are older medical device models that may still be in use by providers and can present significant risks because they might not have software updates or patches needed to ensure security. So be well aware if there are older devices that you are using, those should be monitored very carefully because they might not be up to snuff with more recent security software requirements. So Ryan, anything to add on this topic or any of the other topics before we move to questions?
No, I think that's good. I mean, the one thing that we've been doing recently is we're working with more boards on cybersecurity issues. Sometimes working with an audit committee to address those issues under the audit committee's jurisdiction. But some groups are starting to create separate, cybersecurity committees with their own charter, responsibilities, and members, given the the issues, the big issues and technical expertise needed to address cybersecurity issues.
Great. Yep. It's a great idea. All right.
Questions? All right. If you have any questions after the webinar, feel free to call or email Catherine or me. I'm happy to answer your questions offline. Maybe give people 20 more seconds to send in their questions. Otherwise, enjoy the day.
Yep, and we'll put in another plug for next month's webinar with David Glazer on the 60-day rule.
All right. Thanks, everyone.
Thanks, everyone.